So good afternoon, everyone, and welcome both to those who are here in person and those who are joining us online to this first CELS lunchtime seminar of the term. It gives me the greatest pleasure to introduce our speaker today, Professor Orla Lynskey, who is Professor of Law and Technology at University College London and a long-standing friend of this faculty. So Orla studied at Trinity College Dublin, the College of Europe, and in 2009 came to Cambridge to write her PhD on data protection. At the time, that was an emergent area of law, and Orla was one of the very first to work in that area. And since then, she has become a leading light in the field of EU digital law and policy, as it is confirmed by her meteoric academic career. So immediately after the completion of her doctorate, she secured what is today an assistant professorship at the LSE. She then became an associate professor, and last year she was appointed to the chair of law and technology at UCL. She has published very widely, including a monograph by OUP in 2015 and numerous articles in top journals in the field. So as you can imagine, we have a wonderful seminar in store for us today. Orla is going to talk today about something that sounds very enticing, digital empire or digital fiefdoms, the role of the EU as a digital power. And without any further delay, I'm going to leave the floor to Orla. Thank you.
Thank you, Albertina, and thank you, Sophie, for the invitation to offer a lunchtime seminar. And thanks for everyone here for giving up your lunchtime to attend. So today, you'll notice that I've changed the title for the talk slightly from the one advertised to focus a little bit more narrowly on the right to data protection in the EU. But before I get started, let me tell you a little bit about the impetus for this work. So this is a co-authored paper with colleagues Katie Nolan at the Technical University in Dublin and Maria Murphy at Maynooth University, which was born out of some work that we did last year for the Department for Economy in Northern Ireland, which had commissioned some research asking us to examine whether or not proposed changes to the UK data protection framework would risk the kind of adequacy status of the UK for transnational data flows from the EU to the UK. And so essentially what the Department for Economy wanted to know was if the UK law changed as proposed, whether the UK would no longer be recognised as adequate for EU data transfer purposes. And what we noted in kind of doing some kind of deeper investigation of the European Commission's practice in this area was that we could see a clear kind of chasm opening up between the case law of the Court of Justice of the EU on the right to data protection and the decisional practice of the European Commission when it comes to adequacy. And so really what we're trying to do in this paper is to present that kind of empirical research, but also to think about what broader implications that has for the protection of fundamental rights in the EU, and in particular for this question over who gets to determine the content of the right to data protection in the EU legal order. And so the title, Digital Empire or Digital Fiefdoms, comes from Anu Bradford's work, where she examines the regulatory systems or the approach of the EU, the US, and China to artificial intelligence and to digital technologies. And she characterizes the EU's approach as one that promotes rights-centric regulation. And I think our kind of initial hunch on this was that that is not nuanced enough, that the Court of Justice is pursuing a very rights-centric approach to digital regulation, but in fact that many other factors inform the European Commission and the legislature's approach now to data protection. So in other words, we can't speak of the European Commission or the European Union as a single digital empire. Rather, it's a series of digital fiefdoms, each with their own objectives and motivations when it comes to digital regulation. So before we get started today, apologies because I understand a lot of people in the room have knowledge of data protection, but I think there's some kind of necessary background context. So the first thing to note is that from the very outset, and here you see some text from the 1995 Data Protection Directive in the EU data protection policy has pursued dual economic and human rights objectives. And so the early case law of the courts in particular was characterised by its emphasis on data liberalisation, ensuring the free flow of data and securing market integration in the EU. Whereas once the EU Charter of Fundamental Rights acquired binding status in 2009, and with the entry into force of the TFEU, the Court of Justice was given a hook onto which it could anchor its jurisprudence in a more human rights-oriented way. And so what we've seen since then is that the court is systematically emphasising the significance of the right to data protection in the EU legal order and the need for complete and effective data protection. So really strong human rights jurisprudence from the Court of Justice in this area. Where we have seen resistance to this, and where we've seen debates around resistance to this, has been coming from the constitutional courts of the member states, which have to some extent challenged the EU's supremacy in terms of its interpretation of these rights. And I think you see this in case law like Le Quadrature du Net and other cases. And so we've seen that resistance on the vertical axis, I would say, so member state to EU. But what I think is interesting about what the adequacy scenario reveals is resistance on the horizontal axis. So a kind of a tension between the Commission and the Court of Justice in this area. So here, whether we would characterise this as a constitutional dialogue between the Court of Justice and the Commission, or simply a horizontal dialogue about the substantive data protection requirements is something that we're still kind of discussing amongst ourselves. But the overarching question for today is, to what extent are intra-institutional dynamics in the EU shifting the centre of gravity of the right to data protection? So in terms of the way in which the presentation today will unfold, I'll first just provide some brief introduction to what I mean by adequacy and why it's important for EU data protection law. I'll then do a kind of a slightly deeper investigation of the decisional practice of the European Commission when it comes to adequacy. And then we will kind of start to try to tease out some of the legitimacy questions that we think that this decisional practice gives rise to, and the way in which it demonstrates this intra-EU contestation over the meaning of the right to data protection. And this is obviously relevant within the EU, but because adequacy decisions are granted vis-a-vis third countries, so non-EU states, this also has huge, I think, implications beyond the EU's borders. So first of all, what is adequacy? Within the legislative framework for data protection in the EU, you have a series of principles and prescriptive requirements for how you legitimize data processing. And once you have legitimate data processing, the idea is that data can flow freely within the EU's boundaries. So the objective of the GDPR is to facilitate that free flow of personal data between member states who are all kind of offering equal protection to fundamental rights. This begs the question, what about when we want to transfer data from within the EU to outside of the EU. And here in Chapter 5 of the GDPR, you have specific, I would call them kind of anti-circumvention rules, which are designed to ensure that when data leaves the EU, it is subject to an adequate or equivalent level of data protection. So you see this here in the last sentence of Article 44. All provisions in this chapter shall be applied in order to ensure that the level of protection of individuals guaranteed by this regulation is not undermined. So we don't want the protection of individuals to be undermined when data leaves the EU. And so as a result, in the data protection framework, you have a series of mechanisms that allow or that must be complied with before you can transfer data from inside the EU to outside of the EU. And the one that we'll focus on for today is this notion of adequacy decisions. And so with an adequacy decision, the idea is that the European Commission examines the law, the entire legal framework and the constitutional framework of a third country, so a non-EU country, or a sector of the economy in that third country, and assesses whether or not it offers adequate data protection. And if so, the Commission adopts an adequacy decision, and the data can flow freely from, let's say, the EU to the UK, because the UK has an adequacy decision at the moment. So from the perspective of the data exporter, this is the preferred position, because it means that you can have the data flow freely from, let's say, the EU to the UK without the data exporter having to put in place any additional contractual mechanisms or other safeguards. And so in that sense, it's the mechanism which has the least kind of regulatory burden attached to it from a data controller's perspective. We have, though, had some very significant case law from the Court of Justice of the EU about the meaning of adequacy. And so, in particular, we have two judgments stemming from the activities of privacy campaigner Max Schrems. So the first case, in this first case, Max Schrems, an Austrian activist, privacy activist, had challenged data transfers from the EU to the US in the aftermath of Edward Snowden's revelations around national security. And his argument was simply that once the data landed in the US, there was no way, based on Snowden's revelations, that we could consider that the level of protection offered to that data of EU residents was adequate. And so in this case, from a substantive perspective, what was important was that the court interpreted adequacy strictly. So it says adequate protection means protection that is essentially equivalent to that offered by the EU. So you have adequacy as essential equivalence. The other thing that's important about the case is that, I think there are two things that are important, two further things. The first is that in assessing adequacy, you're not simply taking into account the data protection law in that non-EU state, you're taking into account the entire constitutional framework. And so in the Schrems case, what was kind of decisive in practice was national security access to data once the data landed in the US. And interestingly, from our perspective for this paper, was that the court said that the Commission's decision here should be subject to a strict standard of judicial review. So the Commission had significantly reduced discretion in this area, and the justification given by the court was because fundamental rights were engaged. So that, I think, becomes important. After that Schrems 1 judgment, the practical consequence of that was that the main mechanism for data flows between the EU and the US was invalidated immediately by the court. And so in reality, all of the big tech firms shifted to use contractual mechanisms to allow data still to flow from the EU to the US. So again, Max Schrems argued that de facto, the level of protection in the US remained unchanged, and therefore these data flows were still illegitimate. And so this was challenged again in the Schrems II judgment of the Court of Justice. And here again, we get some interesting insights from the court, where it says, when you're assessing adequacy, the level of protection offered has to be assessed in light of the EU Charter of Fundamental Rights. So we're concerned here with fundamental rights protection assessed in light of the Charter. And the second kind of notable thing about this judgment was that the privacy shield, which was another adequacy decision that had been adopted between the EU and the US, was again invalidated on the basis that when the data arrived in the US, there were inadequate opportunities, amongst others, for individuals to challenge the use of their data, challenge to mount any kind of judicial review or any kind of judicial investigation about the use of their data in the US. So there were kind of inadequate judicial remedies. And the court said that this affected the essence of the right to an effective remedy. So again, you have the Court of Justice invalidating the Commission's decision. And so why do I think this is important, or why do we think this is important? Well, I think the first thing to note is that politically, these were hugely consequential judgments. So they were received, I think, in very different ways in different quarters. So on the one hand, civil liberty activists and those concerned with the protection of fundamental rights more generally very much welcomed the judgment as kind of a robust response to surveillance in the US. So you can see here Edward Snowden congratulating Max Schrems for changing the world for the better. It was President Obama at the time, his response to the judgment was to say that it was a protectionist judgment from the Court of Justice, which was very much about protecting the EU's economic interests in retaining data locally in the EU. And, just one quote from Stuart Baker, a prominent member of government in the US at that time, said that this was a gobsmacking mix of judicial imperialism and Eurocentric hypocrisy. So there were, to put it mildly, strong reactions to the judgment. What else could we say? Well, as things developed, this also started to have clear economic consequences for transnational data flows. So after the invalidation of first the Safe Harbour decision and then the Privacy Shield decision, and while we were waiting for the adoption of a third decision, we can come to that, the Irish data protection regulator threatened to suspend all data transfers between the EU and the US from the big tech companies that had their lead establishment in Ireland. And a strict reading of the law, or just a regular reading of the law, would suggest that that should have happened immediately anyway. But just to kind of reiterate here, I think there are two things that are important about this kind of jurisprudence. So the first is the court is saying that these commission decisions are subject to a strict standard of review. And the second thing is that the court is actually providing quite prescriptive criteria for the commission in determining the content of these adequacy decisions. And this has been resisted to some extent by the Commission. So all of this is quite well known in the public domain and often debated, the legitimacy of the court's actions here, et cetera, et cetera. What has been subject to less scrutiny, I think, is the detail of the adequacy decisions and the Commission's practice in this area. And so on this project for the Northern Irish Department for Economy, what we had the opportunity to do was to kind of look behind the scenes at the existing adequacy decisions to see precisely what was happening in terms of the adoption of these decisions. And if you look at the adequacy decisions we have so far, we actually have very few. So we had 11 adequacy decisions adopted under the 1995 rules and also the US Safe Harbour, which was invalidated. And then since the entry into force of the GDPR, we've had 3 adequacy decisions, 4 because the UK has 2, let's say, plus this recent recognition of the US as adequate through this data privacy framework. So we don't actually have, excuse me, my voice is going to let me down, term time. We don't actually have a huge amount of decisional practice on adequacy. But what you can clearly see, looking at these decisions, is that there has been a big shift in institutional practice pre and post GDPR. So very superficially, it looks like things have gotten better because the adequacy decisions post GDPR are a lot longer. So they look to be a lot more detailed. But in fact, I think what is happening behind the scenes is a little bit different. So before I explain any more, just to say, we said the European Commission adopts these adequacy decisions, but the other actor involved in this context is the European Data Protection Board. And so this is an EU body that is comprised of the regulators, a member of each kind of regulator at national level participates in the EU Data Protection Board. And so it's a representative body involving each of the data protection regulators. And under the 1995 rules, what we could see was it was the predecessor to this European Data Protection Board, the Article 29 Working Party, which was taking the lead on adequacy decisions. So looking at various decisions like Faroe Islands, Hungary, Israel, New Zealand, Uruguay, you see that this Article 29 Working Party is asking questions of the data protection agencies in those countries, is really kind of trying to interrogate what is happening on the ground. Post-GDPR, the Commission has totally marginalized the role of the European Data Protection Board. So instead, what happens now is rather than the EDPB engaging directly with authorities in the country being investigated or appraised, the European Data Protection Board is simply provided with documents by the European Commission. And this seems to be causing some problems in practice for the level of scrutiny then of adequacy in these non-EU states. So here what you can see is in this first paragraph, a quote from the Japanese appraisal by the European Data Protection Board. So the appraisal of the adequacy of Japan from the European Data Protection Board. And what the European Data Protection Board says is that following analysis of the Commission's draft adequacy decision, the EDPB notices that a number of concerns, coupled with the need for further clarifications, remain. So what's happening here is the EDPB is being provided with the adequacy decision. It's still expressing concerns, but nothing is happening about those concerns. Similarly, and maybe even more drastically, when the UK was being appraised for adequacy, the draft implementing decision was adopted, and then the EDPB was consulted on this. So as part of the formal adoption, but really giving the impression that any input the EDPB would offer at that point wouldn't necessarily be taken into consideration in the draft decision. So we see, I think the first thing is a marginalization of this expert input, which would have the effect of increasing the level of data protection for new adequacy decisions. Similarly, when it comes to the review of existing adequacy decisions, so the Commission has not so long ago completed its first review of the 11 existing adequacy decisions, and various people have expressed discontent that some of the countries that continue to be recognised as adequate are in essence inadequate for substantive reasons. Well, I'm not going to kind of go into the substance of this, but just from a procedural perspective, again, what you see is that because the Commission is simply reapproving these adequacy decisions, it does not seek the input of the EDPB. And this is because it wasn't formally consulted by the Commission because no adequacy decision was repealed, amended, or suspended. And so it was only in the event of a change of adequacy status that the EDPB would be consulted. And again, here what the EDPB says, you can see it in this first sentence, is that the information that it was provided with in the staff working document from the Commission is far less detailed than something like a draft adequacy decision. So again, it's kind of complaining that as an expert body, it's not getting sufficient information for it to adequately, pardon the pun, assess the decisions here. And, a little hint to the Commission that the EDPB stands ready to be involved in the next periodic review. Please don't ignore us again. But there's no obligation on the Commission to do so. So what we then see is marginalisation of the EDPB in the adoption of new decisions, marginalisation of the EDPB in the review of existing decisions, and then the third thing, and perhaps the most problematic thing here, is a real difference between the content of the Commission's adequacy decisions and the guidance from the court. And so here you can see this in this paragraph, which comes from the first review of the US data privacy framework, where the EDPB is saying that we have quite clear guidance, both from the European Court of Human Rights and from the European Court of Justice, about the need for prior authorization of surveillance measures by a judicial or an independent body, and that this requirement isn't reflected at all in the US data privacy framework. So substantively, you have a divergence between the requirements of the Court of Justice of the EU and the ECHR and what the Commission is requiring in its adequacy decisions. So that's just one example. I think you'll find lots of these. Another example is a really basic one on the definition of what constitutes a transfer. So bizarrely enough, the GDPR doesn't define what a transfer of data is. And so this has led to all kinds of questions about whether making data available on the cloud constitutes a transfer, et cetera, et cetera. But the European Commission's approach has been that there is no transfer of personal data if the entity in the non-EU state, again, let's say in the UK, is already subject to the GDPR. And it could be already subject to the GDPR, for example, because it's offering goods or services to EU residents or for other reasons. And so in these situations, you might have a company in Mexico that offers goods or services to individuals in Spain, and therefore which is subject to the GDPR because of that activity of monitoring the activity or the behavior of individuals in Spain. And the Commission is essentially saying you transfer data to them. That's not a data transfer for GDPR purposes because they're bound by the GDPR anyway. Just to note here that this is again out of line with the guidelines of the EDPB and recent jurisprudence from the General Court in the EU. So the Commission is again kind of going its own way in terms of the protection it is offering. So just to sum that up, we've seen this limited or marginalized role for the EDPB in the adoption and review of decisions. We've seen a kind of a selective approach to the integration of guidance or requirements from the Court of Justice and the European Court of Human Rights into the Commission's decisions. And I think a query, at least, about whether or not the Commission is pursuing a more political agenda through the adequacy decisions rather than a fundamental rights agenda or an agenda of kind of legal protection. So what then are the consequences of this? Well, and this is, I think, where we'd be really kind of grateful for input, but in thinking about this, what we thought was quite striking was that this looks like a kind of a new site or a new area where you see intra-EU human rights contestation. So as I said, if you look at a lot of the human rights literature in the EU, we have a lot of attention to the kind of dialogue between member states' constitutional courts and the EU courts on that kind of vertical plane. We see some engagement with the Court of Justice and the EU legislature around the extent to which EU legislation complies with the rights found in the EU Charter. But here, what you really seem to see is the Commission pushing back, at least implicitly, against the fundamental rights jurisprudence of the Court of Justice in a way that isn't really referenced at all, where it doesn't seem like there are any other analogies in EU law. We didn't expect this. You expect the guardian of the treaties to respect kind of the judgments of the European Court of Justice. And I think there is a query here about what is motivating the European Commission. And so this is a quote from this first report on the review of adequacy decisions. And I think you could read this in a few different ways, but one reading of this is that the Commission is seeking to pursue economic ends through adequacy decisions, because it says, rather than being an end point, adequacy decisions lay the foundation for closer cooperation between the EU and like-minded partners. These decisions have opened up commercial channels for EU operators, as well as easing cooperation with foreign partners in a broad range of regulatory fields. So this could just be saying the free flow of data makes everything else possible, greases the wheels for commerce. But this could also be read as saying we're using adequacy decisions to kind of achieve more economic ends. And I think this stands in really stark contrast to the approach of the Court of Justice here, where the court, and this is a quote from Kuhn Lennertz on the Schrems 1 and 2 cases, when he was speaking outside of his judicial capacity, where the message from the court is really that the court rises above all kind of political and economic implications of its judgments. And so he says it's a matter of upholding the requirements of EU law, the rule of law, and of fundamental rights. And if this is also affecting some dealings internationally, why would Europe not be proud to contribute its requiring standards of respect for fundamental rights to the world in general? Okay, so that has all kinds of imperialist undertones that we probably won't discuss. But the message really is that the court is interested first and foremost in respect for fundamental rights and upholding the Charter. So what should we take from this? Sorry, I think the first thing to note is at the bottom of the slide, so apologies, which is that the standard of review here is very different to other areas of EU activity where there is a huge amount of deference to Commission decisions. So all the competition experts in the room will know that the court typically says that in matters of complex economic or social issues that you will have a very limited review of or a deferential approach to the Commission's initial decision. So this is the polar opposite to this, and this is justified by the fact that we are in the realms of human rights. So one critique of that would be kind of the idea of juristocracy, that the judicial apparatus in the EU here is kind of taking over or is interpreting the right to data protection in a way that doesn't necessarily have political support. And this is something that we're starting to see discussed in the EU literature. So Paul Craig, for example, observes that while before the entry into force of the EU Charter, the EU was rarely kind of legislating in the area of fundamental rights. And so this question of the extent to which the court should respect the approach or the perspective of the legislature on the content of fundamental rights was never really a question that was on the table. Whereas he says now, the interpretation of Charter rights may well be contestable. There will be inevitably cases where the courts substitute their view for that of the legislature. And therefore, this counter-majoritarian aspect, the legitimacy of the court in making these types of decisions will be increasingly questioned. However, our kind of perspective on this, I think, aligns to that of Elise Muir, who is another EU fundamental rights scholar, who I think correctly notes that Commission adequacy decisions don't benefit from any kind of democratic legitimacy. And so in her kind of explanation of Schrems, what she said is that the strict review process operated in Schrems can be kind of justified by the fact that the political decision invalidated was one that came from a body with weak political accountability. So the court doesn't necessarily need to be deferential to the Commission in this instance, because this isn't necessarily a decision that carries any kind of democratic weight. And we think that that argument is kind of strengthened further by the fact that the EDPB is so marginalized in this process. Because the EDPB here is meant to act as kind of a counterweight to ensure that, in this instance, the perspective of member states is kind of represented in the Commission's decision. So it acts as a kind of an equivalent to comitology. And so what lessons can we kind of then take for this? Well, I think this in some ways offers an answer to the question about the legitimacy of the court's approach in adopting adequacy decisions, or in invalidating these adequacy decisions. So I think you clearly see that these aren't political decisions, but in fact that this is the court kind of upholding, doing its job. But the kind of serious underlying question is, what happens when the Commission continues to challenge, in effect, the legitimacy of the courts in doing that? So what happens if the Commission continues to deviate from the court's guidance here? But I also think that this helps us to think about the recalibration of the right to data protection that we're seeing beyond adequacy decisions. And we're kind of toying with whether or not the space in this paper for this. But what the EU has done recently is adopt a whole suite of legislative acts, a Data Act, a Data Governance Act, Digital Markets Act, and many others, which kind of shift the centre of gravity of data protection away from fundamental rights protection and more towards the economic dimension of data processing. And so I think an important query then is, to what extent, if these acts were kind of challenged before the Court of Justice for not respecting the right to data protection, would the court be able to be so kind of robust in its imposition of its definition of data protection on the EU legislature? And there, I think the answer is a lot less clear-cut, because this legislation has kind of democratic legitimacy, whereas the implementing acts of the European Commission through these adequacy decisions do not. So this is where we have gotten to with the paper, but feedback is very welcome. Answer questions, and thank you for your attention.